today I will present on a judgment. I'm sorry. I will present on a judgment that it draws my attention. I don't know if you have read this case, but this is the constitutional case of Estrellita. The official name of the case was The Rights of Nature and Animals as Legal Subjects, but it's better known as the Estrellita case. This case was delivered by the Constitutional Court of Ecuador in February of 2022. And when I read it last year, it gave to me so much impressions about that maybe the rights of nature framework is not the appropriate framework for the recognition of rights for animals. And I will explain the reasons of why. But first, we will start by an introduction of the rights of nature of Ecuador, in Ecuador, in the legal system of Ecuador. So, in 2008, Ecuador promulgated for first time in the constitutional tradition a constitution that recognizes rights for nature. The Article 10 of this constitution declares that human beings, natural persons, communities, nations are rights holders, but also recognizes that nature is a rights holder, but only in relation to the rights that the Constitution recognizes for it. And that rights are established in the Chapter 7 of the Constitution. And basically are three rights: the right to integral respect for its existence, the right to maintenance and regeneration of its life cycles and evolutionary processes, and the right to be restored. When the Constituent Assembly of this Constitution recognized rights of nature, they have two main goals in mind for this recognition. First, to overcome the Western hegemonic pattern to move towards the recognition of the intrinsic value of nature, and to face the threats of development, foreign investments, and mining activities. As you can see, these two goals of the recognition of rights of nature indeed are very populistic declarations. Is to because there is a big movement in Ecuador to recover indigenous knowledge and to respect for indigenous people, etc. And also because in Latin America, there is a big sentiment, the people, or at least the majority of people, is against international or transnational investments that are taking the national richness, the national resources of your country, no? So the people is watching that they are poor, but there are transnationals that they are taking their gas, they are taking their oil, their gold, etc. So there is a big sentiment in Latin America against transnationals. And for that reason, also for the recovering of indigenous knowledge and indigenous values, is that the Constituent Assembly of Ecuador has recognized the rights of nature. In relation to the definition of nature, we have in the Constitution of Ecuador that they define nature as where life is reproduced and occurs. And because of this definition, initially, the doctrine on environmental law and rights of nature and the case law of the Constitutional Court of Ecuador interpret that nature are physical spaces, such as lands, rivers, mountains, national parks, etc. But progressively, and more concretely in 2021, in this case called Los Cedros, the Constitutional Court of Ecuador recognized that animals are also rights holders and legal persons under the rights of nature, but only as a species, not as individuals. And this recognition was made because for the court, when you have a high number of species, when you protect a species, animal species, you are creating a more resilient nature. So as you can see, the recognition of animal species as legal subjects under the rights of nature has like an indirect intention of recognize their intrinsic value. Is because you, at the end of the day, you want to protect nature. But this recognition of animals as legal subjects, as a species, changed in 2022 with the recognition of animals as individual animals as legal subjects and rights holders in the Estrellita case. In this case, the court used the following argument. It is recognized already that the rights of nature protects animal species according to the Cedros case. Los Cedros case. Animal species are made by individual animals. And what happened to one animal will have an impact on the whole species. And consequently, to protect nature is important, or will imply the protection of individual animals. And also, the court established that if we want to protect nature, we have to protect individual animals. And to decide, it will be very arbitrary to decide how many individual animals have to be protected or have to be endangered in order to activate the rights of nature. How many animals will be enough? The court answered, no? 1, 2, 3, or the whole species. It would be arbitrary to establishing a law or to give to a judge the discretional decision about this. So consequently, the court established that all individual animals have to be declared legal subjects in order to be protected by the rights of nature. Now we will see a little of the story of Estrellita and what about this case. Estrellita was a chorongo monkey or woolly monkey. Woolly monkeys are the most threatened monkey species in Ecuador, both because of loss of habitat, but also because there is a big illegal hunting of these animals for food and for illegal pet trade. We have that Estrellita lived with Ana Beatriz for 18 years since she was one month old. And with this fact, and talking with the lawyers of the family of Estrellita, I discovered that the case of Estrellita is not any illegal pet trade case. It's not a case where a family had a woolly monkey as an exotic pet or an exotic attraction. Indeed, Ana Beatriz identified herself in the case as the mother of Estrellita. And according to the lawyer, Estrellita was very integrated as a family member in the family of Ana Beatriz. We are talking about the so-called multi-species family. I know that Estrellita had a space in the house. Estrellita was participating in parties. The family of Estrellita was taking her existence into consideration when they were traveling, etc. So it's a very particular situation. In September 2019, because of an anonymous complaint, the Environmental Authority of Ecuador arrived to the house of Estrellita, and they confiscate Estrellita using physical force by using police in a very coercive way. And the same day, the Environmental Authority put Estrellita into a zoo, in the San Martin Zoo in Ecuador. And because of this, Ana Beatriz was prohibited to visit Estrellita. First, because the zoo was closed due to COVID restrictions, but also because when she was requesting the Environmental Authority to see Estrellita, the Environmental Authority denied her. So she was unable to see Estrellita for a long time. And for that reason is that the family of Estrellita, with the help of the lawyers of this animal organization called Victoria Animal, they filed a writ of habeas corpus asking to the environmental authority or the state that the family can have legally to Estrellita, the delivery of Estrellita, but also asking for a special permit that allowed they to have Estrellita legally. And they filed this writ of habeas corpus, and there were a hearing in 2020, in February 2020, and in this hearing, the environmental authority gave notice about the death of Estrellita. That is, for 4 months, the environmental authority didn't give notice to the family of Estrellita about the death. And consequently, the writ of habeas corpus changed, and now the family asked for the delivery of the body of Estrellita. Both the lower court and the Court of Appeals dismissed the habeas corpus action, and for that reason is that the family and the lawyers filed an extraordinary action before the Constitutional Court of Ecuador as last resort. And the Constitutional Court of Ecuador issued the judgment in 2022, in January 2022. In this case, the court recognized animals as legal subjects and Estrellita as a legal subject, and the court declared that the rights of Estrellita were violated at 3 different times. First, when Estrellita was taken from her natural environment, because at that moment, one, you are taking the animal outside from their environment, but also because probably the person who hunted Estrellita also killed the mother, because this is a regular practice in the hunting of woolly monkeys. 2, the court established that the rights of Estrellita were violated when the authority take off Estrellita from her house, because the authority didn't consider the special emotional attachment of the animal towards her human family. And finally, in a 3rd time, where the rights of Estrellita were violated is when the environmental authority put Estrellita into the zoo, because the court didn't consider that a zoo was not appropriate environment for a monkey who was living with a human family for 18 years. So as you can see, the court made a big work in identifying every stage of the life of Estrellita where her rights were violated. Nevertheless, with this funding, the court established that the body of Estrellita it was not possible to give the body of Estrellita to the family, because for the court, the body of dead wild animals have to receive phytosanitary treatment for sanitary reasons. Nevertheless, what is more important for us today is the ruling. What says and how is that the court established that animals are rights holders and legal subjects under the rights of nature, and which rights they are recognized, and how we have to interpret these rights. Well, first, we have to know that the Estrellita case is binding jurisprudence in Ecuador, so it will have the same legal effect of the judicial precedent in the common law in the whole Ecuador, until a new overturning, until a new judgment that will overturn this case. So when the court established that, as I explained before, that animals are legal subjects because their protection is important for the whole species and at the end for the whole nature, the court resolved very quickly the question of personhood and the person of rights, if animals are rights holders. There is not so much work about that. And in the whole judgment, with this recognition, what the court did is that the court began to recognize a set of different rights for wild animals. It's important to say that the court didn't refer rights for domesticated animals, but in no part of the judgment, it established that domesticated animals don't have rights. And there is this general statement that all animals have rights now in Ecuador, but the court only recognized a list of rights for wild animals because the case was about the Estrellita, that was a wild animal. And the recognized rights are as follows. You have the right to life, the right to physical integrity, the right to exist, the right to not be hunted, the right to habitat, the right to not be object of humanization processes of force to assimilate human characteristics, the right to free development of animal behavior, the right to not be domesticated, the right to freedom, the right to good living, the right to have a diet in accordance with the species, the right to live in harmony, and the right to health. Nevertheless, all these recognized rights, according to the court, had to be understood and interpreted according to two principles. First, the interspecies principle, and second, the ecological interpretation principle. The interspecies principle made reference that the protection of animals and the recognition of their rights have to be done taking into account the characteristics of the species of the animals, of a certain animal, the characteristics, processes, life cycles, structures, functions, evolutionary processes of each animal species. For instance, the court give this example: the right to respect and conserve the areas of distribution and migratory routes is a right that can only be protected in that species of animals with migratory behaviors. And this is a similar interpretation, a similar principle that a court in India used when they recognized the right to flight of birds. For instance, in this case, the court said, birds have a fundamental right to flight and cannot be caged and will have to be set free in the sky. So they are recognizing certain rights according to the capacities of certain animals, no? But what is more important for me, and what I will talk about in the rest of this presentation, is the second principle, is the principle of ecological interpretation. According to this principle, what the state have to do is to respect and protect biological interactions that exist between species, because these biological interactions are the foundation of the equilibrium of ecosystem. And for this reason, the court established that all public authorities are obligated to ensure that biological interactions have to be maintained and have to maintain their natural balance. What are those biological interactions? Are competition, antagonism, commensalism, mutualism, but also that biological interactions in which some individuals benefit from others by causing them harm or death, such as predation or parasitism. From an environmental perspective, the maintenance of natural balance and the respect for biological interactions is a plausible goal. Nevertheless, for animal rights or human rights, the protection of biological interactions and natural balance is very problematic, and I will explain why. When the court established the principle of ecological interpretation, in order to explain this principle, the court gave two examples. The first is in paragraph 102 and said, when a predator kills its prey in compliance with the trophic chain, the right to life of an animal is not illegitimately violated. And immediately after, in paragraph 103, the court gave this example. As human beings are predators and being omnivorous by nature, their right to feed on other animals cannot be forbidden. And in this way is that the court found the way to establish rights for animals without without taking humans their legitimacy to continue eating animals. The court found a perfect justification for the continued use of animals for food. But the eating animals is not the only human practice legitimized by the court in this case, because also the court, in relation to the ecological interpretation principle, told the same. First, in relation to domesticated animals. Domesticated animals can be used for transportation, for helping work, for clothing and footwear, and even for recreation and leisure. In relation to wild animals, the court established that they can be captured for ex situ conservation, as this practice enhances opportunities for environmental education, research, and scientific development. And also, the court established that even when animals are recognized rights and as legal subjects in Ecuador, the National Environmental Authority may carry out the necessary actions to control species populations, especially when it is a matter of eliminating invasive, exotic, or introduced species that may endanger the balance of ecosystem. So, even when the court is recognizing the right to life, the right to exist, the right to physical integrity, the right to not be hunted, the court has established that under the ecological interpretation principle, all these rights can be undermined by human interest in this way. So my question, when I was reading the case, the judgment, was the following. What is the point of recognizing rights of animals if those rights can be undermined by any human interest? And I realized that in this case, and under this construction of animal rights under the rights of nature, what the court was doing is to establish biological interactions, was treating biological interactions as restrictions for the rights of animals under the rights of nature. And this is wrong, because restrictions can never be imposed on rights in an arbitrary way. We know that in human rights, there are some fundamental rights that are considered absolute. For instance, the right of torture, or the provision of the provision of torture and the provision of discrimination, for instance. But the most of rights can be subject to restrictions, because we have to exercise our rights in relation to the rights of others. Nevertheless, these restrictions never can be imposed in an arbitrary way. Rather, there are three conditions for the imposition of rights, restrictions to rights. And we know that is legitimacy, that the restriction must correspond to a very strong reason to impose restrictions on the right of the individual. The condition of legality, that the restriction must be in accordance with law, transparently and with legal safeguards. And proportionality, that the restriction must be proportionate and necessary for the fulfillment of the objectives pursued. The restriction should not go beyond what is necessary. All this international scheme for the imposition of restrictions is plenty recognized for rights, for human rights. Nevertheless, in the case of Estrellita, the court never established, never referred to these conditions in order to establish that biological interactions are restrictions for animal rights, or never talks about a similar scheme for the regulation of the arbitrary restrictions on rights for animals. Instead of doing that, and from my point of view, what the court has done is to recognize rhetorically rights for animals, but at the end of the day, the court has found in the biological interactions and natural balance and perfect argument to justify the continued use of animals for human interest. And consequently, from my point of view, the rights of animals under the rights of nature is not more than other welfarist conservationist system for animals, where the biological interactions and natural balance are the new necessary suffering. Because in welfarist regimes, you have this justification of necessary suffering for use animals as you want or for any reason. And in the rights of nature framework, rights of animals also can be this framework, the rights of nature for rights for animals, also is using the biological interactions and natural balance in a similar way. Because at the end of the day, you can justify any use of animal under a biological interaction and a natural balance, as we have seen in the previous examples given by the court. Consequently, I consider the rights of nature is not a framework for protect individuals. We have that rights of nature is aimed for the protection of the environment, but not for the protection of individuals, because the protection of individuals demands a different scheme, a different legal structure of rights. Mountains, rivers, and forests, they need the maintenance of their natural balance, they need the maintenance of their natural characteristics, they need the protection of a pristine landscape. But individuals with an intrinsic interest, and as we know, no, animals and humans, where you can say that there is one inside of the body, individuals with intrinsic interest, they need rights that will recognize on them intangibility, but also autonomy. And these rights never obey to what is natural. These rights will go beyond what is natural. Because, for instance, in the case of human rights, we know that it's very natural to have a virus, to have bacteria, to have parasites on nature. But that is not an excuse or a restriction for obligate the state to carry out vaccination campaigns under the right to health of humans. And because if we will establish that what is natural is per se okay, it would be to fall in a naturalistic fallacy. And we know that naturalistic fallacies are, in the most of the time, are in contrast of human rights, because it's like to say that because women can have children, they are obligated to have children, or to say that because an homosexual couple cannot have children, they don't have the right to family or the right to marriage. So we are applying a naturalistic, we are working, rights of animals under the rights of nature necessarily carry with this naturalistic fallacy, because apparently all animal rights have to maintain their natural balance, their natural characteristics, how they are in nature, etc. But we know that that is not okay for individual animals, because animals as individuals with intrinsic interest, they need more what is natural. They need to go out from that natural space that demands them a lot of suffering, or maybe also in contrast to their nature, they can develop emotional attachment to human families, like in the case of Estrellita. So that is not natural for the animal species, but it is okay, and maybe is the best way of living for that specific animal. So for that reason, I consider that the rights of nature is not the appropriate framework for the protection of animal rights. And this is a scheme that I made, thinking how is now are now the rights, how the rights of nature and rights of humans are living together in the Constitution of Ecuador. As you can see, as we have seen, we have a different scheme for human rights and a different scheme for rights of nature, and consequently a different scheme for rights for animals. And what we are doing is to have two different kinds of rights inside of one same constitution, that is the Constitution of Ecuador. On one side, you have the rights of humans, and on the other side, you have the rights of the rest of nature. And necessarily, these rights always will be undermined by the rights of humans. We know the reasons of this, because it always is more important to protect humans than other elements of the environment. So with this differentiation between different rights in the same constitution, what we are doing is to reinforce this duality that animal lawyers have been denouncing for so much time, no? On one side, humans, and on the other side, the race of nature. And for understand this, I want to see with you, for instance, the right to life. The right to life for humans is recognized in Article 66 of the Constitution of Ecuador. But there is another different right to life that the Estrellita judgment have recognized for animals. These both rights, even when they have the same name, are definitely different, because one is founded in human dignity, as we know, and the other is founded on rights of nature. And as we have seen, rights of nature only have 3 rights in the Ecuadorian Constitution, and specific rights that are aimed for the environmental protection, for the protection of landscapes, etc. And there is a paper that it was very important for me in doing my paper about this, and it's the paper of Jordi Jaria Manzano. The name is "The Rights of Nature in Ecuador: An Opportunity to Reflect on Society, Law, and Environment." And in this paper, Jaria Manzano established that the rights of nature framework, even when the rhetoric that you want to give value to indigenous ideas and the protection of intrinsic value of nature, at the end, rights of nature continues operating within a notion of social rights and welfare state. So within a Western economic model, where nature necessarily will continue being a provider of resources. For instance, in Article 74, we will see that Article 74 recognizes that humans have the right to benefit from the environment. And also in the Constitution, in that Constitution that recognizes intrinsic value to nature, etc., the Article 407 established that it is prohibited the extraction of non-renewable resources in protected areas, but this prohibition this prohibition can be changed if the president of Ecuador has the consent of the National Assembly. No, so at the end of the day, the intangibility of natural areas and the elements of the environment are not founded in their intrinsic value. Rather, they are founded in a political decision. They will be protected. The right to integrity of a landscape is not protected by the inherent value or the intrinsic value. Is protected always that a political decision exists for protect that environment, and the same, So we have seen that even when the rhetoric of the rights of nature is recognizing intrinsic value to nature and its elements, from my point of view, the ultimate outcome of the rights of nature in general is to serve humans with the healthiest environment possible to provide them welfare and economic growth. Because we have to remember always that environmental protection, and in this case, rights of nature, are rights that always will clash with the right to development of people. Because we cannot have development if we are not touching, if we are not changing and using our environment. For instance, and I am not talking about just right to have a business or the right to have a technology with you, etc. I am talking about the most basic rights, such as access to water. For instance, to access to water for big populations in the world, they need to touch natural resources, resources of water. To have access to food, under the right to food, necessarily you have to change natural ecosystems for croplands. So always there will be this clash between the right to development and the protection of the environment and environmental rights. So that is a question that we have to take in mind. To conclude, what is what I think, how I think that we have to continue working is that we must not put more effort asking for rights for animals under the rights of nature. That is what the people want to do now in Ecuador. Rather, as lawyers, as animal lawyers, what we have to do is continue fighting for full rights for animals independently from the rights of nature. So we cannot, we have to separate rights of animals from rights of nature. And we have to fight and we have to go towards the recognition of the rights of animals and animals as right holders with fundamental rights that derive from the same foundation than the rights of humans. No? And I don't know about rights of nature. I don't know if in the future we will have rights of nature or not. That is another discussion. What I want to put focus is that we cannot agree to have rights of humans and rights of animals with different foundations. We have to achieve rights with the same foundation. It could be dignity, it could be basic necessities, etc. Vulnerability, I don't know. But we have to continue fighting for a union between rights of animals and rights of humans. And yes, that was my presentation. Thank you so much.